liberty of a person has always been a talk of everyone, especially who's behind the bars. And anticipatory bail and regular bails are the two facets. But today we will not be discussing as such, but we are primarily focusing on what are the changes brought forth in the new BNSS Act versus the, we can now say, old CRPC. Here are the different changes, different challenges. And amongst us, we have a renowned speaker who's also quite close to the knowledge sharing process. And we are glad that Mr. Trikram and Associates have been able to help us connect with M.S Shyamsundar, a senior advocate from Karnataka High Court. He's an erudite speaker coupled with the fact that his knowledge delves into deeper subjects of law. With BNS coming into forth, there's a lot of curiosity amongst the lawyers and other people. What are the changes brought? I'll ask Mr. Trikram to say a few words, and then thereafter, Mr. Shyamsundar will take you. Over to you, Trikram.
Thank you, Mr. Vikas. Sir, we are so glad to have you on this forum, especially a person with in-depth knowledge on criminal law. This is a juncture where there's a shift, and we are all in need of this webinar, and especially from a erudite person like you who has extensive knowledge on various facets of criminal law, and bail being one of the most integral part or aspect, and the cases that you have dealt in practice are not ordinary cases. So we are all awaiting to get enriched with your erudite presentation, sir. And once again, we are so glad to have you on this forum. On my personal behalf, sir, and on behalf of Beyond Law CLC, sir, I extend a very warm welcome to you. Over to you, sir.
Thank you, Trivikram, and thank you, Vikas, for having given a good introduction of me. And a very good evening to all the participants today who are directly on this webinar through the Zoom link. And a very good evening to all those who would be watching this on the live streaming. Of course, when Vikas and Trivikram asked me about what subject do we talk about, I preferably opted to talk about the law of bails under BNSS, because there is some addition and some changes into the law of bails, which was a much required need by the time we had the new law in place. And particularly coming to the definition, as we all know, the CRPC, the Criminal Procedure Code, never defined what the bail was. So in BNSS, there is a beautiful definition that is given to the bail, and certain more changes have been introduced. And one of the major changes is that section 83, which deals with transit bail, which in fact we had earlier, but not under a particular provision of law, but under certain common law judgments, we did have the provision of seeking transit bails, but there were certain conflicting judgments, and some of the judgments said that the transit bail cannot be given by a non-jurisdictional court, and some of the judgments said as a transit bail can be given by a non-jurisdictional court. The transit bail was also a part of a matter of controversy, and was also a matter of challenges at several junctures. Many times the transit bail, which was being the powers of the transit bail, which was being exercised by the non-jurisdictional courts, was in fact misused. And sometimes there have been instances that the transit bail was granted even when the person was not arrested. Transit bail was granted in a style of anticipatory bail. So therefore, to put an end to what exactly has to happen to a person or his liberty status when he is being arrested by a non-jurisdictional at a non-jurisdictional place, and he is produced before a non-jurisdictional court, and if the offense is bailable in nature, or if he has an entitlement for bail otherwise, the law was a bit silent. And BNSS, of course, gives that clarity to us. And of course, there have been certain more changes that are introduced under the BNSS about the the entitlement for an under-trial prisoner who is holed up in the prison and who is facing trial, and if he has already undergone certain period, a term of punishment, a certain term of incarceration, jail stay, unless there is no conviction or no conclusion of trial. There has been some changes introduced, and we'll go one by one. Basically, to start with, as I said, the Criminal Procedure Code earlier did not define bail, but BNSS defines bail. Now, how BNSS defines bail is quite interesting. Let's have section 2, which defines bail. And let me read it straight away from BNSS, because as we are still at an infancy stage, getting acclimatized to the new law, new BNSS, so there is hardly there is something which is not yet by heart imbibed in us, so that we have to read the provision again and again. As lawyers particularly and law practitioners, every time you read law, every time you read a provision of law, you get a different dimension. So better let me not just say something directly, but let me just read the definition under section 2(1)(b), which defines bail means release of a person accused of or suspected of commission of an offense from the custody of law upon certain conditions imposed by an officer or court on execution by such person, a bond or a bail bond. Again, going further, bailable offense is defined. Now, under section 2(1)(d), bail bond is also defined. Bail bond means an undertaking for the release with the surety. Then E defines bond means a personal bond or an undertaking for release without surety. So if we are seeing these definitions, what we gather from these definitions is these definitions have been introduced after much thought and after much dependent upon a great greatly dependent upon several judgments in the common law, where there were confusions. What exactly is the bond? What exactly is a personal bond? What exactly is a cash bond, etc., etc. To put an end to all those confusions, every time we as lawyers, we had to rely upon the judgments of the Honorable Supreme Court or various high courts, and to give greater clarity, these things now stands defined so that no one has any kind of a confusion what exactly is the bail and what exactly is a bail bond and what exactly is the kind of surety, etc., etc. So section 2(b), which defines bail as is a new arrival in the law, and of course it benefits all of us to a great extent. Now, principally we had several types of bails all along. Of course, if I have to say some types of bail which we had, majorly we had 3 types of bail: anticipatory bail, a regular bail, and under regular bail we had bail in bailable offences, bail in non-bailable offences, and we had something called as default bail, and we had also another classification called, which was once again a common law classification, that was medical bail, and there was one more common law classification called interim bail. Of course, under section 438, which dealt with anticipatory bail earlier, we had something called as an interim bail. So during the pendency of the bail application, during the course of hearing of the bail application, the court could grant an interim bail, but this interim bail was missing in the old code, and even now there is no much thing said about the interim bail. So insofar as the interim bail is concerned, we still largely depend upon the common law. That means the judgments of the honorable courts, basically the Honorable Supreme Court and the Honorable High Courts. Now, going to different types of bail, as I said, now anticipatory bail was a concept which was there earlier under the CRPC, continues here. And anticipatory bail was in fact not there earlier. In 1973 Act introduced anticipatory bail. Prior to that, we did not have anticipatory bail, and some of the states did not, in fact, even after 73, did not have the provision for anticipatory bail. So one had to approach the Honorable High Court invoking section 482 of the Criminal Procedure Code earlier, invoking the inherent powers of the court to seek for a pre-arrest protection. But now, a comparative table, of course, it is widely available everywhere. Section 436, which dealt with bail-in bailable cases earlier, now is kept under section 478. Then section 437, that the magisterial powers and bail, when bail can be taken in case of non-bailable offense, that is now settled and kept under section 480 of BNSS. Then 438, which earlier dealt with anticipatory bail, that is the pre-arrest protection, now is kept under section 482 of BNSS. Then 439, the powers of the Sessions Court and the Honorable High Court to grant bail in non-bailable cases, that is basically the serious offences, is now kept under section 483. And of course, there are some provisions with regard to bail bonds, etc., which follows thereafter 484, 485, 486, etc. But basically now, the analogous provisions which are important for the practice of law of bails would be section 478, 479, 480, 481, 482, and 483. So these are the newly, these are basically not newly introduced sections, that are the analogous provisions for the earlier sections, that is 436, 436A, 437, 437A, 438, and 439 of CRPC. Now, there is one more provision which was always there, it's called as default bail. That was earlier there under section 167 clause 2, which is now under section 187. So before we go to section 478, which deals with the regular bail, now we deal with the facet of default bail. So the default bail earlier was that if an investigation cannot be completed in respect of certain offences based upon the gravity of the offences, the length of punishment, etc., within certain period, depending upon the gravity and the length of punishment with the offence carried. If it was the police could not complete the investigation within a certain period, 60 days, 90 days, 180 days, as the case may be, the accused who would be in custody would have got a default bail, which is now under section 187 of the BNSS, and no much change to 167B, 167.2 and 187. The provision as it is continues with no greater change. But there was always something called as the powers of the magistrate to remand an accused person to custody pending investigation. After, in between, once the investigation is over, pending committal proceedings, and after committal proceedings, post cognizance. These were the powers of magistrate. Now, interestingly, section 309, if we read, the analogous provision to earlier section 309, which is now section 346, if we read, I'll just read it, it's quite interesting. 346 clause 1 reads, in every inquiry or trial, the proceedings shall be continued from day-to-day basis until all the witnesses in attendance have been examined, unless the court finds the adjournment of the same beyond the following day to be necessary for the reasons to be recorded, provided that when the inquiry or the trial relates to an offence under section 64, 65, and 66, and 67, and 68, section 70 or section 71 of BNS 2023, the inquiry or trial shall be completed within a period of 2 months from the date of filing of the charge sheet. If the court, after taking cognizance of an offence or commencement of trial, finds it necessary or advisable to postpone the commencement of or adjourn any inquiry or trial, it may from time to time, for the reasons to be recorded, postpone or adjourn the same, and on such terms as it thinks fit, for such time as it considers reasonable, and this is what is important, and may by warrant remand the accused if in custody. So the remanding of the accused was always a must, a mandatory requirement of law. Either it was a remand during the investigation, where the powers during the investigation, the authority to seek the remand is always with the hands of the investigators. It is a prerogative of the investigators that the investigation is still under progress, therefore remand them to custody. Once the investigation is over, the charge sheet is laid, the challan is laid, and if the court comes to the conclusion that the offences are triable exclusively by a court of session and the committal proceedings are yet to take place, in the gap between the charge sheet is filed, that is, the investigation is over and the committal is not yet done, the magistrate had to remand the accused to the custody. Thirdly, under section 309, if the inquiry or trial does not take place and the magistrate has to remand. So unless and until there is a legal remand, either at the instance of the investigation officer or the request is made by the investigation officer to the learned magistrate, or the learned magistrate under the circumstances what we just saw, or either under 309 or after the cognizance, after the charge sheet is filed, there has to be an order of remand, a request or an order of remand. If there is no request or an order of remand, then what remains is the one cannot be remanded, he has to be set at liberty. So this has always been the law. The remand of an accused person to judicial custody or whatsoever the nature of custody is, it has to be by a warrant of a magistrate, and if there is no such remand expressly made, that means a custody of an accused person becomes illegal and he becomes entitled for bail. So why I am saying this is, apart from the scenario what we saw under section 187, where the investigation is not able to be completed and they are unable to complete the investigation within the time prescribed under law, by keeping the accused person in the custody, he gets entitled for a default bail. And in cases where there is no express warrant of remand also, the law is quite clear, and it is a straight and direct understanding of the law of liberty is that one cannot be held up inside the prison without there being a warrant of remand. So this becomes little arguable before the courts, and sometimes why I am pressing on this is, sometimes we see the continuation of the custody of the accused persons without there being an express order of remand. Under such circumstances, what has to be done? If there is no order of remand, no warrant of remand has been caused by the jurisdictional magistrate and the accused still is held up in the custody, then we get a right to approach the Honorable High Court to say that in the absence of a warrant of remand, there has to be the custody has fallen unlawful, a custody has fallen illegal, therefore an illegal detention cannot continue and he is entitled for a release on bail, is what we can always pray. So therefore there is one more bail apart from these provisions, which is in fact hidden bail. That means when there is no legal custody, custody is not by a legal warrant, a lawful warrant, then a person cannot be held up, it becomes an illegal detention. So the relief unfortunately has to be granted by the High Court, because you can't go before the same magistrate in the absence of a remand who must have kept the person in the custody. He might in fact hesitate to pass such an order of bail, waking up to his own errors. Therefore, there is one more kind of bail which is in fact hidden behind the screens. So now we go to section 478, which is analogous to section 436 earlier. No much changes when it comes to 478, that is bail in bailable cases. Bail in bailable cases is always a matter of right, because the Criminal Procedure Code in its schedule and the BNSS now in its schedule attached to classifies the offences as bailable offences or non-bailable offences. When it comes to bailable offences, as the nature of the offence itself speaks, it is bailable offence. where the bail becomes a matter of right. For our young practitioners, I would like to say something. At this, I'll take a pause from going from the text, and I'll just I need to say this because we have been seeing in the courts, even in respect of bailable offences, we have been seeing lengthy bail applications, voluminous bail applications, mentioning too many things in that. It is not necessary in case of bailable offences, because in case of bailable offences, the offence itself by nature is bailable. So the bail is, you are right, you can only say offence is bailable in nature. Therefore, I am ready to offer proper and acceptable sureties, ensuring my appearance before the honorable court or before the investigation agencies whenever it is needed. Therefore, grant me bail. This is more than enough. So you need not to write a rhetoric and say, I have seen bail applications running 10 pages, 20 pages, 30 pages, sometimes in fact, which is redundant. Of course, a lengthy bail applications capturing vividly the facts, innocence, etc., becomes necessary when a person is accused of an unbailable offence, where you will have to tell to the court prima facie what is your defence. Though not, you may unwrap everything at the stage of bail itself. If one is accused of an unbailable offence, for the court to exercise discretion in favor of the person who is facing the imputation of an unbailable offence, the court has to be convinced that yes, this man has some defense of innocence. Therefore, keeping him hauled up inside the jail is not necessary, and by taking certain sureties, we can set him on liberty. This is the discretion which is vested with the court in case of non-bailable offences. In those circumstances, to in fact keep before the court an acceptable or a vivid picture as to what is your innocence, what could be the wrong in prosecution case, why your arrest was illegal, etc., you will have to keep before the court a descriptive bail petition, a descriptive bail application, except that under 436, when you are filing a bail application, that is 478 of BNSS, you need not to write a rhetoric of 10 or 15 pages. It could be a one-pager bail application. As a matter of fact, the law of pleadings exempts the criminal jurisprudence. Under criminal law, there is nothing called of law of pleadings. The pleadings have to be in an order. It has to mention the provision of law. It has to mention everything in a particular order. This is not necessary under criminal jurisprudence. Therefore, see to that your bail applications under 478, when you are seeking bail for bailable offences, it need not to be lengthy. It can be very precise and very simple. So is the case in default bail, which is present section 187 of BNSS, because the default bail is what? The default bail is in fact a blessing in disguise, because you are accused of an unbailable offence. But the investigation is under progress. The law contemplates an upper limit for the investigation to be complete if somebody is held in custody and the investigation is happening, keeping the accused person in custody. So that is 60 days, 90 days and 180 days, as the case may be, depending upon the gravity and the length of punishment which is prescribed for the offence. Under those circumstances, if the investigation officers are unable to complete the investigation within the prescribed period, you get entitled for a default bail. That means your merits are not looked at, your innocence is not looked at. The only thing which is looked at is the default by the prosecuting agencies, that is particularly the default of the investigation officer in laying charge sheet against you. Charge sheet means the culmination of investigation. Once the investigation is over, the culmination of the investigation, he has to lay a report before the court that this is the investigation, these are all the evidence which I have collected. If he fails to lay such a final report of investigation before the court within the prescribed time, it is because of his default you are getting bail. Therefore, even a default bail application can be as simple as this. 2 lines would suffice. Number 1, I was arrested on so and so date in respect of so and so non-bailable offence. Then I have been in custody. Number 2, the offences carry such and such length of punishment, which in respect of which the upper limit for investigation is prescribed under law, as the case may be 60 days, 90 days or 180 days. In spite of the efflux of time, that is the time for laying the charge sheet is over, the investigation is still underway. No final report is laid. Therefore, I am ready to offer acceptable sureties. Set me at liberty. This is all which is required. Because at the time of granting bail, that is bail under section 187, 167, earlier CRPC 167 clause 2, the court will not look at anything except the default committed by the investigation officer. Therefore, you need not to once again write a rhetoric or a detailed bail application when you are seeking a default bail application. In fact, the honorable courts, there are some judgments, they have gone to the extent of saying that even a bail application is not necessary. The courts themselves, the magistrates themselves will have to offer this bail if they notice that the investigation is not complete within the prescribed time, by asking the accused person that, are you ready to furnish surety? If he is not ready to furnish surety, he of course foregoes that. If he is ready to furnish surety, the court has to compulsorily grant bail. But given the situation that the courts may not be following every case, because the load which is on the court, it is first duty of the person representing the accused or accused himself to keep a tab on the day spent for the investigation and the day when it is getting over, and seek and press for his right immediately upon noticing the fact that within the time prescribed the investigation is not yet complete and there is no charge sheet. So, as I told, once again, for this and bailable offences, no need of detailed bail application. Then we come to, in 2005, the Criminal Procedure Code earlier introduced a provision under 436A, which is now, of course, kept under section, if I can take you to section 479 of BNSS, this is analogous to erstwhile 436A. What is 436A and what is 479 present BNSS? And the lawmakers, the courts always felt that felt a great amount of sympathy for those who are facing trial, hold up inside the jail for a length of time. In our country, as we all know, there is no speedy trial. Speedy trial is yet to happen, except in few cases. We hardly see trials happening at a good pace. The reasons contributing may be many. In fact, we ourselves contribute a large amount of reasons to that. We repeatedly keep taking adjournments, non-availability of the witnesses, non-availability of the court time, the courts clogged with a huge number of cases. So the end result is, because of the delay happening of this side of the court, this side of the bar, the person who is languishing inside the jail keeps on getting deprived of his right to live and right to liberty. So the courts felt, the lawmakers felt, and also the courts repeatedly felt that you can't keep a person inside custody for a long time just because the trial is on. If the trial is unable to get concluded within a fair span of time, so then he has to have some right to get entitlement to come out on bail and continue facing the trial. Therefore, 436A was introduced. So 436A said that if the accused person who is inside the custody has already spent half of the term, which could be the maximum term of the punishment that would be awarded to him in respect of the offences for which he is facing charges, he should be granted bail. Now, 479 goes a step further. 479 has good additions under BNSS and quite significant development made on the law of bails. 479 reduces the time to 1/3. Now, let me just read 479 so that we have a clear insight. Where a person during the period of investigation, inquiry, or trial under this Sanhita of an offence under any law not being an offence for which the punishment of death or life imprisonment has been specified as one of the punishments under that law, undergone detention for a period extending up to 1/2 of the maximum period of imprisonment specified for that offence under law, he shall be released by the court on bail, provided that where such person is a first time offender who has never been convicted of any offence in the past, he shall be released on bond by the court if he has undergone detention for the period extending up to 1/3 of the maximum period of imprisonment specified for such offence under law. So the length of time which was earlier, the yardstick was more than 1/2. Now it is 1/3. So the length of time which he has spent in jail during the trial is reduced, provided further that the court may, after hearing the public prosecutor and for the reasons to be recorded in writing, order the continued detention of such person for a period longer than 1/2 of the said period, or release him on bail bond instead of his bond, provided also that no such person shall in any case be detained during the period of investigation, inquiry or trial for more than maximum period of imprisonment provided for the said offence under law. So there are certain explanations added. So the new addition, the improvement and the development which is made under BNSS is that it safeguards the right of under-trial prisoners. Of course, under Indian conditions, our jails are overclogged and in fact overcrowded, that they're clogged. The jails which have been built for a maximum strength of 1,000 are holding now 5,000, 10,000. Therefore, the life inside the jail is very, very horrible, and no conviction, no pre-trial conviction in the guise of keeping him in the custody can be is acceptable under the jurisprudence. Therefore, the new provisions has been introduced, and if he has undergone already under the circumstances which I just read, 1/3 of the term which he would get as punishment for the offence which he is facing, the charge of the offence which he is facing, the courts have the discretion to release him on bail. So this is a new development which is under BNSS. Then going to 480, which deals with the magisterial powers of to grant bail in respect of non-bailable cases, which was earlier 437 of CRPC. There are certain changes where hearing of the prosecutor is made a must. The hearing of the prosecutor, unless and until the opportunity of hearing the public prosecutor is made, the powers under 437 cannot be exercised. That is made. One second. See, we have so many judgments. Why BNSS has so many improvements is because there have been several judgments which have been laid down and which has the force of law, and the nectar of all those judgments have been reduced. And apart from the nectar of the judgments which have been reduced by provision, by way of provision of law, there is also the recommendation of Law Commission in the under the changed circumstances, which has contributed to some changes in respect of the BNSS provisions, particularly having regard to the law of bails. Now, 438, which dealt with anticipatory bail earlier under Criminal Procedure Code, is now kept under 482 of the BNSS. So 482 of BNSS has certain changes. That means the right of seeking anticipatory bail is taken away in respect of certain offences. Just let me read it. The right to seek anticipatory bail is taken away in respect of certain offences. That is 482 subsection 4. Nothing in this section shall apply to any case involving the arrest of any person on accusation of having committed an offence under section 65 and subsection 2 of section 70 of Bharatiya Nyaya Samhita. That is the heinous offences like gang rape, rape of a girl below the age of 16. Under these circumstances, the right to seek anticipatory bail is taken away. Of course, we had earlier also under certain special legislations, the right to seek anticipatory bail was regulated. For example, the offences under the Prevention of Atrocities, SC/ST Prevention of Atrocities Act, there was a specific departure from application of 438. Of course, few other laws also had such provision excluding the applicability of 438. Of course, under those circumstances, the available remedy was to go before the special jurisdiction of the Honorable High Court under Section 482 and seek for bail. However, having incorporated so many changes under law of BNSS, having incorporated so many changes in respect of provisions of bail, the special provisions governing bail under circumstances under special statutes, for example, PMLA, for example, NDPS, where the rigor of certain sections which are preconditional in nature. To grant bail, the courts have to record additional reasons of being satisfied that there is no repetition of offense and a probability that he is not committed offense. These kind of provisions, what we see under PMLA and NDPS, those continue to exist, which are in addition to the bail provisions of the BNSS provisions. And now 430, 483 deals, both 483 of BNSS deals analogous to 439 of earlier criminal procedure code, that is bail, the powers of sessions court and the powers of the Honorable High Court to grant bail in non-bailable offences. Basically in cases where the accusations are grave and the gravity of offences and the length of imprisonment, the length of punishment prescribed for the offences are larger. So that continues to be as it is. So the important changes that have been introduced under the BNSS are Section 83, transit bail. Much clarity is given and we need not to bank upon the common law provisions and the earlier judgments governing the transit bail. I want to read Section 482 of BNSS once again to make sure that has BNSS got, or whether BNSS continues to have something in the nature of the interim bail protection what we had earlier under Section 438. Let me just read it, very interesting. When any person has a reason to believe that he may be arrested on accusation of having committed a non-bailable offence, he may apply to High Court or the Court of Session or for a direction under this section, and that court may, if it thinks fit, direct that in the event of such arrest, he shall be released on bail. And the High Court or the Court of Session makes a direction under subsection 1. It may include such condition in such directions in the light of the facts of the particular case as it may think fit, including a condition that the person shall make himself available for interrogation by police officer as and when required, a condition that a person shall not directly or indirectly make any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to any police officer, a condition that a person shall not leave India without previous permission of the court, such other condition as may be imposed under Section 3 of Section 480, as if the bail was granted under the section. If a person is thereafter arrested without warrant by the officer in charge of police station or such accusation, and is prepared either at the time of arrest or at any time while in the custody of such officer to give bail, he shall be released on bail. And if the magistrate taking cognizance of such offence decides that the warrant should be issued in the first instance against the person, he shall issue a bailable warrant in conformity with the direction of the court under subsection 1. Nothing in this section shall apply to any case involving the arrest of any person on accusation of having committed an offence under Section 65 and subsection 2 of Section 70. So, what we see, Section 482 now hasn't got that express provision, which earlier, Section 438 earlier mandated that when a notice is issued, the moment the anticipatory bail application was filed, the court either had to dismiss or grant interim bail. If the court doesn't want to grant interim bail, it's as good as the application is dismissed. If the court wants to hear the prosecution, then he had to have an interim bail, because pending the consideration of the bail, if he is arrested, the very provision, very right which is bestowed upon an accused person who is apprehending arrest, a person who is apprehending arrest under Section 438 will get will render in fact without purpose. It would as good as a provision which has which serves no purpose. Therefore, earlier 438 had this kind of a room where there was a compulsion, and which we in fact also see when the Honorable Supreme Court dealt with Sushila Kumar Agarwal's case, where the Honorable Supreme Court clearly said that yes, interim bail can be granted, but even for the interim bail, prosecution may be heard. But under 482 now, the anticipatory bail provision has in fact not got such a room where we can seek for interim bail. Now, the question is whether the right to seek interim bail is taken away by BNSS. The answer may be no, because earlier also the law of interim bail was largely governed by the common law. That means the judgments of the various Honorable High Courts and the Honorable Supreme Court. So, the Honorable Supreme Court had laid down law that even in case of non-bailable offences, regular bail also, the court can grant interim bail under certain circumstances. And of course, before finally considering the anticipatory bail, the interim bail was a possibility. Of course, there is no direct provision now, but the law continues to operate. Of course, the common law, we still have none of the one very beautiful part of the BNSS is BNSS does not undo any judgments which laid down law and which had the force of law. For example, BNSS has never made any attempt to bring down the rigor of any judgments. For example, take for example Sanjay Chandra, great law on bail, Sidram Satlingappa Maitre, great law on bail, the latest Honorable Supreme Court in case of Kejriwal, great law on bail. We have had several judgments, in fact, which define what is bail, and we have certain judgments which define what is bail in respect of special offences under PMLA, etc. So, BNSS does not attempt to bring down the density or bring down the essence of the judgment law or the judgments which were operating, and therefore the judgments which we always relied upon whenever the law was absent for the purpose of bail continues to operate, and we shall continue to reap the benefits of the judgments which have been holding the field. At the end of the day, my opinion is that the law of bail itself is a conception to protect one's liberty. Of course, BNSS brings in something new. What is that? All along we have had the Indian jurisprudence, particularly we have had the accused, the idea was to protect the innocence of a person accused. So the presumption was presume him to be innocent till he is adjudged guilty. Of course, till today we continue to have the same jurisprudence, but we were in fact giving more prominence to this philosophy as against the victim-centric justice. So the rights of the victim, the rights of the complainant, the rights of the victim, in fact, most of the time was subdued. Therefore, BNS makes an attempt that victim-centric justice is also taken care of, and therefore introduces certain exceptions that when anticipatory bail cannot be taken in respect of certain heinous offences like gang rape, rape of a girl who is below the age of 16 years, and BNSS also takes care of a situation that unless and until the prosecution side is totally heard, and there have been judgments, of course, we have been using these judgments very frequently these days, that the right of victim to be heard at the stage of bail. We have been using those judgments of the Honorable Supreme Court in Diljit Singh's case and few other cases, where the victim, besides the prosecution, has a separate right to come and oppose the request of bail set up by a person accused. The idea is that when the investigation is at a nascent stage, at an infant stage, it is not the investigation officer who knows much about what is the background of the accused, what is the background of the person who has sustained injury due to the crime, what is the background of the victim, what is the background of the complainant, etc. It is none other than the victim who knows more than them. It is none other than the complaint, and there has to be some balance struck between the rights of the victim, who is expecting justice at the hands of the state, and as well as the rights of the accused, who is expecting justice at the hands of the state to show his innocence. So this balance was lacking. BNSS makes a certain amount of a clear attempt to strike some balance by introducing these provisions. Of course, as I said, Section 83, which deals with transit bail, once again, it accrues to the benefit of an innocent person, who is likely to be framed. If we go back to the days of Macaulay, when the law was framed, provision like Section 161 of CRPC earlier and Section 162 of CRPC earlier, which particularly said that no statement taken by the investigation officer or a police officer should be signed, and it should not be used in evidence except for certain limited purposes. Why such kind of a provision was kept was to not to continue the state as police state, because it was quite expected that a vesting of extreme powers at the hands of the police would certainly be misused, and there would be a great likelihood of power being corrupted, power being used for corrupt purposes. That is the reason the lawmakers had ensured that large powers were not given to the hands of the police, and there was a judicial scrutiny was always maintained. Now also the law continues the same, especially when we see the recent judgments of Arnesh Kumar, Satyendra Kumar, until the Honorable Supreme Court has gone on sitting on Arnesh Kumar and Satyendra Kumar until giving repeated directions to various high courts and the states to implement strictly the observations and the law laid down therein, just in order to protect the innocent persons from being arrested and subjected to the ignominy of them being lodged into custody and them being kept in police custody or whatsoever. Now, though the term of the police custody earlier, which was 15 days, now it stands extended. Though the term of the police custody is extended, we always had a bottleneck to go and ask for bail when the person was given to the police custody. Of course, there were certain judgments that even when a person is in the police custody, just because his statement has to be recorded, disclosures has to be taken from him, he is in police custody, he cannot lay a request for bail. There were judgments to say that the right to apply for bail was not taken away even when somebody was in police custody. BNSS makes a specific provision that after the first 15 days, if the police custody is continued, because the law extends, now the BNSS extends the police custody. If the police custody is continued, after 15 days, you can make an application for bail. So that preventive view that until and unless one continues to be in police custody, he cannot be seeking for bail. Only when his police custody ends, he can apply for bail. So that has been demystified and BNSS clarifies it. So whatever the case, along with the law, BNSS or earlier civil procedure, criminal procedure, code of criminal procedure, what has been guiding our courts repeatedly in respect of law of bails, more than the law, are always were and are always been the judgments of the Honorable Supreme Court and the judgments of various high court. I recall the recent remarks made by Honorable Chief Justice in several of his speeches and several of his statements, that why are the lower judiciary are hesitating to grant bail? Particularly, why are the sessions judges are hesitating to grant bail and just simply passing bucks? Why are there more rejections? Why are the jails getting crowded day by day and they're clogging? Why not you be liberal in terms of granting bail? Even the latest Supreme Court judgment, His Lordship Justice Oak has clearly said that please grant bail. At the end of the day, your bail is not an acquittal. So you are just protecting a person. when he is facing trial and you are giving him complete liberty to design his defense. One of the major reasons to set a person at liberty was also that if you are accused and if you are kept inside the custody, a person who are well-to-do, good circle outside, they can always design a great defense. But what if he has none to design his defenses except him? So he has to be outside. He has to be under a congenial atmosphere to go design his defenses, engage his lawyers, engage the lawyers of his choice, and so many things he can do. Otherwise, the justice will be, there are large chances of betrayal of justice. Therefore, the courts have always been conscious, notwithstanding the fact that the victim-centric justice is also given prominence, is also given priority. The law has always been that don't keep somebody in custody unless until it is imminent, it's extremely necessary, and please allow him to be at large pending trial. And don't ever think that just because one is enjoying the relief of bail, he is already enjoying an acquittal. So tomorrow when the case is concluded and the court holds him guilty, he'll always be imprisoned. He'll always be put back into the prison. Therefore, the judgments in particular have given us more insight than the provisions law by itself, that when bail has to be taken, we generally get confronted with a question that what is this? Yesterday the Honorable Court said that bail should be given, and today the Honorable Courts are saying that the bail should not be given. Yesterday the Honorable Court said that why did this High Court or why did this Sessions Court refuse to grant him bail? And today the Honorable Supreme Court is saying why this High Court or why this Sessions Court granted bail in this kind of cases. So we have been seeing judgments which are differing day by day. Do we say that the earlier judgments are incorrect and the changed view of the Supreme Court or changed view of the Honorable High Courts are so uncertain so that we don't have clarity? The answer is the law of bails always deals with peculiarity of a particular case. There cannot be any one straight jacket or a straight line formula that in these type of cases, please grant bail. In these type of cases, please don't grant bail, especially when dealing with bail in non-bailable offences. Therefore, every case has to be looked at from its background, the intention, what exactly was the design of offence. So many things matter. Therefore, there could be cases where the Honorable Supreme Court refused to grant bail. There could be cases the Honorable Supreme Court reprimanded and said the bail has to be granted. Therefore, all that we as practicing lawyers have to do is first look at the facts of our case. What is the outlay of the facts of our case? Whether the facts of this case fits into the settled law. What is the best judgment which I can use for my case? Quoting simply Sanjay Chandra, quoting simply Kejriwal, which does not even remotely match to your case, gets you no relief even if you quote the best judgment on grant of bail. First, you will have to trace the case, trace your case, the facts and circumstances of your case to a judgment which is available in hand. Trace your case, trace your facts to the best judgment, and then seek for bail. That because the circumstances in my case are akin and similar to this particular case, please grant me bail. And in respect of unlawful arrests, the arrests which have been done without following the mandate of certain judgments, particularly Arnesh Kumar and Antil, of course, courts have now started to exercise their powers to say, first they will look at if the arrest was effected by following the strict procedures as laid down under law. If they are not followed, the custody is not authorized. And of course, all these provisions which we had earlier, all the provisions under the Criminal Procedure Code which dealt with these situations earlier continues to operate. No much changes. Of course, I may not say great changes, but there is certainly a greater development and a greater insight has been laid under BNSS into law of bails, and the greater importance is also given to protect the liberty of the person, and at the same time, vice versa, a great care has been taken to send a strong message to those offenders who are ruthless and to save the rights of the victims who always cry for justice. I think this should be sufficient for the day, because I am just looking at the clock. We are left with 3 minutes. I would certainly be happy to join for a longer or a series of sessions again. Thank you, Vikas. Thank you, Trivikram. And thank you, all of you who have been in this session. And let me continue to be with you. And more particularly than me continuing to be with you as a speaker, I would like to continue to be on this webinar series as a participant, as a learner, because every day is a process of learning. Every day is a process of studying. Somebody else may know certainly something more than me, and it will be a pleasure to be associated and meeting all of you again and again. Thank you.
Thank you,
One
Mr.
pertinent thing, Mr. Vikas, one pertinent thing I would like to mention before Sir is not only a practitioner, prior to that, he also has experience as a teacher. That is why that academic bent of mind is so well flaunted in his presentation. And there are a lot of his students who have joined that I wanted to mention. That is why I took my out of turn, I pitched in.
Thank you. Thank you so much. I was teaching in University Law College for some time. I was teaching in University and Krupanidhi College, and I was teaching in few other colleges for some time. But due to the increased practice, I felt that I was not doing justice, skipping court, sometimes attending classes, and skipping classes, sometimes attending the course. Of course, even now I keep visiting colleges as a guest speaker, and it's always a pleasure. The happiness of teaching is, of course, something which is beyond everything else.
That's true. Just like Vikram has nailed it, the session was spot on. But before we take any questions, I would like to ask if, as a young lawyer, sometimes the case comes, what do you think that once that FIR comes, what documents, etc., should be collected, or what should weigh in the mind while preparing and drafting the case? Firstly, during the consultancy with the client, and secondly, while preparing, what all nitty-gritties have to be kept in mind?
My message is, as I first said, if it is a bailable offense, there is no much paraphernalia required, because it's a matter of right. If it is a non-bailable offense, if an FIR comes, my message to all my friends is that there is one habit which is now getting nurtured in one lateral of legal practice. That means give a new story which is untrue. Simply say, simply set up something which is knowingly false. I was not there, I was elsewhere, all these things. First, as much as possible, put the facts, and then facts, put the truth as it is on paper. If you feel your client is innocent, then put the facts as it is, because truth always protects. It is like a hard rock, no one can change its shape by doing anything and everything. Therefore, put the facts as it is without spicing it up or without mixing it with something which is not true, without mixing the truth with untruth. Secondly, take instructions from your client properly. So many times, we don't even have patience to listen to our clients. So many times, they say, "Arey, मैं देख लेता हूँ यार. I'll take care of us. Pros, ये सब नहीं सुनता है यार. मेरे को लिखने दो." So most of the times, as I have seen in my initial days of practice, especially when I used to go to magisterial courts and all, very often, the bail applications are always prepared by some typing pool person who is sitting there typing, bail applications in routine. So you will have to put your mind, you will have to put your facts straight, because a bail application is your first declaration of innocence. That is where you first say, "I am innocent." Therefore, the bail application is the first chance to say what your story is. Otherwise, when do you get that chance? Only after 313 is recorded and the court says, "Do you have something to say?" Till then, it is only the prosecution story. No defense story is entertained. Therefore, the bail application is the first place where you say what is your story. And finally, after 313 is recorded, when you are called upon to explain if there is something which you have to say. Therefore, put everything truthful and as much as possible in an understandable way, which should be convincing the court. First thing is, your bail application should first few paragraphs are the story what you are going to project. It should show your innocence. It should show that the probability of accusation is what is against you is improbable. Secondly, your background. Thirdly, your capabilities to offer sureties. All these things you will have to stack it in an orderly manner without confusing the courts. Courts, most of the times, they get irritated because your bail application is a jumble. You're not even telling the things in an orderly manner. You pick up a story in some place, your paragraph number 1 is not in succession with your paragraph number 2 does not correlate to your paragraph number 1. Your paragraph number 3 has to be somewhere in the end, it takes place. So therefore, ensure that an orderly bail application is prepared. Give all the details as precisely as possible in the beginning. Then tell what is your innocence. Then if you have some stories to add up, if it is real, tell why you are being falsely implicated. When the judge looks at the bail application, for him it should be easy, and at the same time it should look real. It should not look like one stereotype innocence bail application. So by keeping a proper bail application in respect of non-bailable offences, where you are seeking bail, proper and legible, a clear, crisp bail application, you are achieving your object 50% in the beginning. So you are winning the mind of the judge. At the end of the day, it is a discretion. You will have to win the mind of the judge. You may not want to win the mind of the prosecutor, because prosecutor will always tell something against you. You have to win the mind of the judge, because it's the discretionary power which is being exercised. A good bail application will win the mind of the judge by half. Secondly, your behavior. When you are asking for a discretionary relief, you have to be humble. The context matters a lot. You may have a great case of innocence, but if you are adopting audacity, if you are asking something as a matter of right, see, at the end of the day, the judge is also a psychological personality. So don't fall into the trap. No judge is going to tell that because you spoke louder, I am rejecting your bail. So your loudness, your audacity, your voice, your bombastic arguments should not cost the client at the end of the day. Why all the lawyers are not successful? Why only few lawyers are successful? Please learn good court crafting in lines of the ethics. That by there you win your case by 75 to 80%, and then what is left with the judge is only 20%. 20% he will be forced to exercise in your favor. Therefore, when you are seeking for a discretionary relief, keep all these things in mind. Don't confuse the court and wait for your turn. Don't see. And lastly, Vikasji, I want to say this. See, for us, our client is more important. For our client, he is only important because it is his case. For me and you as legal practitioners, few of our cases. In a day, you might sometimes have 3 or 4 bail applications. So your cases are important. At the same time, for the court and the prosecution, there are several stories. For the court, it is hundreds of cases. Therefore, just because your client is pushing you, you don't push the court. Aji chahiye. Please give it today itself. Try to consider it today itself. It is easy for the judge to write an order of dismissal than writing an order of allowing your application. It's very easy to write an order of rejection, because I am not satisfied. Prosecution has said like this, therefore there is chance of prevailing upon the witnesses, etc., rejected. At the same time, if he has to grant bail, he has to first appreciate your innocence, particularly in cases where the rigorous provisions operate like PMLA, etc. Therefore, keep yourself low, keep yourself cool, keep yourself obedient, keep yourself an erudite lawyer.
Thank you, Mr. Shyam. You've just explained it how nicely that you can't move with the breeze like a tree, but you just have to be humble like a grass, so that you are rooted to the ground realities. And I can call out that you have said that for any aspect of law, you first have to understand the practical aspects of the bail. Then you have to have an emotional intelligence connected with that. And thereafter, you also have to develop the art of critical thinking, and thereafter thinking on the feet. So thank you, Mr. Shyam, and thank you, Trikram, for staying connected with us. And we would definitely be with Mr. Shyamsundar with more and more sessions.
Keep me posted. It's my request that keep me posted of all your webinars, so that, as I told, I would like to be more happy to be a participant than a speaker. I
have shared with the other people the WhatsApp number wherein we have the Beyond Law CLC group, as well. If you're connected with our session, YouTube channel of Beyond Law CLC, Instagram and LinkedIn, you will always get connected. But I will share that number.
We'll add sir to our group, our Beyond Law CLC group.
Yes, definitely. You will add more knowledge aspects to our group. Thank you, Mr. Shyam. Just akin to your name, the session was actually Sundar.
Thank you so much. Thank you.